My name is Millie Thompson. I'm running for Hays County Court of Law number 3. This is a new court that was created in 2018, and currently there is an incumbent who was appointed by the Commissioner's Court for that court. Mr. Fusco and I will have that Republican challenger, whichever wins in the general. Now, for those of you who do not know much about the court system and don't live in the courts like he and I do, I'll explain a little bit about it. There are Class C cases and small amounts of money cases that are filed in the lowest level courts, JP and municipal courts, right? So when you're talking about getting a speeding ticket, your speeding ticket's gonna lie in a municipal court or JP court. Then you have county courts at law. In Hays County, the county courts at law handle cases ranging from probate cases, like when you have a loved one who has died, guardianship cases, as well as civil cases where the amount that people are fighting over ranges from $500 up to $200,000. And then misdemeanor cases like DWIs and possession of small amounts of marijuana. Okay, so that's county court at law. And then you have district court, where you have cases like murder, robbery, and then when folks are fighting over large sums of money in civil cases. So those are the court levels. And we're running for the middle one. We're running for Hays County Court of Law number 3. A little bit about me. I grew up in green pastures in Kyle, in a mobile home. After it was repossessed, we moved around a bit. My educational background, I graduated from Reagan High School in Austin, and then I went to Texas A&M University, and then grad school at the University of Houston, and then I got my law degree. I've been practicing law for the last 10 years, and I have my own law practice. I've been handling cases, all of the types of cases that are filed in Hays County Court Law number 3, and I'm asking for your vote.
Thank you. Tony?
So for the last 10 years, I've handled a wide variety of criminal cases where my clients had mental health diagnoses, ranging from juveniles who had been diagnosed with oppositional defiant disorder to adults charged with serious offenses who had been diagnosed with a variety of serious mental health issues. I have gone through the process of having clients challenged for competency. I have even gone to a jury trial on the issue of competency, where essentially what you're doing with competency is there's an argument that the person does not understand the nature of the case or doesn't understand the nature of the judicial system such that they cannot stand trial. I have extensive experience defending folks with mental health issues, both defending the cases that they're charged with, as well as dealing with the underlying mental health diagnoses.
Thank you, Lieutenant.
So, here's what happens when you're arrested. You're arrested day 1, and then you're magistrated, where you're told that you have the right to remain silent, the right to an attorney, what you're charged with. And that magistrate, then sets your bond amount. For misdemeanor cases, like in the county court of law, that bond amount may be anywhere from $1,000 to $5,000, just depending on the seriousness of the charge and depending on the person. The amount is supposed to be calculated to make sure that that person comes to court and faces the charges. In our constitutional republic, you are presumed innocent when you're charged with a crime, right? And so, presumption of innocence, but the person's got to come to court and face the charges. In order for us to eliminate any problem with backlog that is coming from the misdemeanor courts, what I would do is review the bond as soon as possible after that person's been arrested. Make sure the bond was not set too high, and that it is not set an amount that essentially is oppressing the person because they don't have the money to get out of jail.
Thank you so much, Mary.